The number one.
Yes, how can it be? How can it be? You have to follow the procedure of law. You will not issue a show cause. You will not issue anything. Can you do it?
And that is the admitted fact that no
So on that technical ground, we are just wanting it.
Yes. But so far as state's power not
No.
privy to the contract, still then.
No, that is, I'm not going into that aspect. We are simply going into the aspect that how can you do it without a show cause notice,
Yes.
without giving an opportunity? You can't do that. Both has to go. Whether the state retains a power or does not retain a power is a matter you decide it.
To that extent, I had prepared a small note, but
We are not going into that. Where is that judgment, our judgment?
And then the Supreme Court judge.
Yes. Erusian, I think, the Grosson, then Panda,
security as well.
Panda,
Gorkha.
last time he handed over.
Oh, where is that? Oh, something is. You're relying on Khulja.
Because these are on the grounds of actual level.
No, we just.
Panda, your lordship can hand it over to the judge.
Yes, we are having it. Khulja is, we are having it.
Panda Infra has taken note of all the judgments of Gorkha security and Eurasia and everything.
I have, with Justice Raman has taken all the.
In Vinodini Infra also, your lordship have passed a detailed judgment. But so far as Panda Infra is concerned, your lordship may kindly see para 24 and.
Both I have seen. That was a very, I would say, alarming judgment where the flyover collapse and casualties were there. But still
this is a case of public health.
Correct. There is still the court says proportionality, you can't do it eternally.
Without
5 years.
putting a reasonable opportunity, it should not have
You
been.
can't. No.
That extent.
Where is that judgment? No, UMC and all, everything was considered by me in my judgment.
I gave this.
You do not know. You do not know our own.
I gave the Supreme Court judgment.
I have considered UMC. Every judgment was considered by me.
It says that what not only show cause, what the show cause should be saying.
No, that
everything
is there.
We are not entering into that. We will be only entering into the one aspect without a show cause.
Yes.
What it should contain, we are not entering into that.
May I just submit one thing about this petitioner actually had.
Just give us the paragraph. Unnecessarily why? Which paragraph?
There, Your Lordship, I have noted it down in the front of the judgment, the paragraph.
Where you have written?
Front of the
Bottom, Your Lordship. In the bottom.
The bottom.
Your Lordship, I have reflected the paragraph.
No, para 35, 38.
So that this is settled with it cannot be because stop. Hey, look.
That contract works are related to the other things, not with the nursing. They are the person who's the make fraud and engaging them, they are nurses.
Oh, now Khulja, I can. Khulja is very clear. Doesn't. Khulja is very clear. Paragraph 26. Khulja, you have given permanent. It talks about the permanent department. Yuvalaji, what I said? Taking into account.
from the collector to the NCL, then these are the things you can.
No, he was talking about the authority of the government. We said we will not enter into that aspect, whether the government has an authority or not.
Right.
That is what we watched. We were very careful. We said that we have not entered into.
Yes. Obliged, madam.
Only on the ground.
Yeah.
That's all.
In the petition, we have made several other reviews, but I advise
Echo.
for other, we go to what.
Who is into?
Item 2.
Virtual mode. Who? Yes. What is this?
I'm on virtual mode, my lord. Tender that the price quoted by the bidder was 32% less than project price. So
32% less than?
less than 32% from the project price, cost price of the project.
An estimated cost.
Rest cost.
Estimated cost. Okay.
So there is a office memorandum of works department and 160 that is
15%.
You-
Your
lordship
hardly started. 15%?
May I invite your lordship to kindly. P122 financial B by 3, my lord. Clause 6 I pay 16, our council. Justification on annual low bids and scrutinized by department technical committee.
Oh, absurdly low.
Yes, extremely low. So he was asked to file the justification. I have at such low price. He filed one.
I have given, your lordship, we appreciate this is the matter, my lord, that was hard at length.
So you can't go, this is what a problem with the virtual. When the Advocate General who is appearing, he is addressing the court and saying that what? We will give you opportunity, we'll come to you. Simultaneously, both you argue, we can't understand your argument and his argument.
I'm sorry, ma'am. I beg apology.
We are asking the government what is his stand. You have already opened your card. We have considered that. Let us consider what is the stand, whether it is justifiable or not. Yes. Then
Page 16 of the Works Department memorandum said that justification on annual low bids shall be scrutinized by department technical committee. This case, technical committee, he was asked by the additional engineer to justify how he can do this at such a abnormal low price. He submitted his first justification. We considered it. We said that you are not properly justified. You
not properly justified. Kindly visualize the situation. He says that I have got these things. I can follow all the mandate of the law. I can supply at this rate. If the government is benefited by that, if a low price is given, it will ease the government exchequer. Why you want to give a contract to a person who quoted a higher price than him, when the government would be benefited from him?
Well, our experience showed that when at abnormally low price, the quoted price abnormally low, in the past and showed they have not been able to execute the work and had a delay. And that's why this memorandum came and that was justified.
Sir, you are taking from him the performance guarantee. You are taking from him the EMD. You are all taking from him everything which is possible to at least cover up whatever the loss which you would suffer. Where is a provision that you will do it in this way, partially? You have a discussion. I understand that clause, but does not mean that on an artificial, you had a some incident, so you will repeat.
But so far the resident part is concerned, you already submitted that is a 10-year-old one message. And you say that you submit the.
Sir, is he not giving a similar kind of a services to other departments or other government agencies? He is. If he knows the trade well, then why don't you take his services? He has an expertise in that. Why? I fail to understand.
And the committee has already explained the rates it has quoted and all that.
Who is that committee? The person who is asking
The department has a technical committee.
he is the head of that, and he himself is the officer who is looking after this. It's a very minute SOCAS which has been submitted by the contractor as to how he will meet it, even at this rate.
Department has made a committee because the memorandum that is says that it should be examined by a committee.
He is the same
So,
assistant
CCI has
engineer.
got the committee.
Kindly, Vidulai, in the paragraph 2, he has very clearly says that I have a sufficient numbers of the supervising staffs and the laborers for execution of a dumping stone work and crate to wall work in the past. I have executed number of same type of works in Gudari zone and Gunupur zone in Raigada district. This area is very much known to me, and I have completed number of works in time during last 20 years. Have you not taken this into account? He says, since last 20 years, I have executed within time.
And again, it has been retendered by ordinance 6.
Sorry.
That what? He has filed on the job. Application Annex 9 filed for reconsideration the further justification that has been submitted by. So, you lordship may directed the committee to consider that within 7 days and thereafter we will go with the.
Chosen a wrong person. I am always against this representation concept.
Rejection tender is full bench decision by Nanda. In fact, it was decided by law that court normally should not.
But there are judgments which says that the court should, once the discretion is exercised arbitrarily, capriciously, whimsically, will it not? I can give those judgments as well. And a recent judgment of 2025.
And during plot time, if it is delayed, then there will be lot
No,
of.
that is what I said. Why you are not, he has an expertise. You have not questioned that he has no experience at all. You have not put.
You lordship may get 7 days time to commit
Sorry.
to reconsider Annex
Nothing.
9
Not a
files.
single question
That
raising.
Annex 10.
Oh, definitely. If it is wrong, then wrong. And then he's given a breakup.
Yes, yes.
No, Annex 10.
Then he has given a complete breakup.
Hello?
He has given a complete breakup.
Yes.
As to how he will meet at this rate. He is having a stone quarry. How he will get the quarry stone at a cheaper rate. Every minute detail has been given in his letter.
The rate is quoted, it is practically found not possible.
You might think.
That is why that was examined and found that is absolutely low and he can do this work.
Sitting in a very comfortable atmosphere, you understand that the work cannot be executed, and the person who is there on the spot and doing the work, his experience will not count. The experience of the person who never visited there, that will count. What are you talking about? This is not the problem.
So the quoted wage part is concerned, they violate the minimum wage doctrine, my lord.
What?
At page 55, we say, the wage and labor charges here say, at page 55 it may be seen, in view of the above, as per clause 6 of the memorandum. of
Just
so and so,
55.
Yes,
Yes.
split petition.
Yes. That is a vehicle particulars of your OA or writ petition.
Read petition.
55. Say that. Yes.
Last para. In view of the above, as per clause 6 of memorandum, dated 3/1/26 of the was departed, it raises a matter concern and it will violate the minimum wage rate guideline which they are fixed by the labor and agriculture department for item number 1 to 6, which is not workable to perform the contract at the offered price. Therefore, your bid is hereby rejected. As per clause.
He is bound. He has given the calculation.
Yes.
He has given a calculation. Please come to your own, the page 25, sir. Page 25 of your opposition, sir. Count it. Please come. Twenty-four. Come from 24. Page 24.
Yes, my lord.
Yes. He has given. First thing is a hard stone 10 kilometers because he is having his own stone quarry. So transportation cost will be much less. He can borrow it from his own quarry. That's the first explanation he gave. And then he says that I can spend this much. Then he analysis of the rates. And then he says the analysis of the rate. Here he has already quoted that how many persons are required to execute the work, how it is to be execute the work, labor, what is there. Have you noted down that this labor will not work at page 25? Then in B also he has given a labor charges. Is it not in conformity with the labor department circular? Tell me. Yes, quoted that I will pay 562. I will pay this. Has he not given everything? Mazdoor, the labor is mason second class, meat, mazdoor, everything he has given. Is it below?
It is the justification of the corporation.
This is, I'm asking, this is his justification. That shows that you wanted to favor somebody. Is it not? That's the impression which is gathered.
Let's be direct on this.
We'll quash it. We'll quash it. We will fresh tender quash it. Has he asked for quashment of the fresh tender?
Tender has already been floated, my lord, for 6/6.
Have you asked for
Yes, my lord.
quashing of the fresh tender?
Yes, my lord. That has been stayed by Lord by order 25C.
Okay.
That has also been
What we have stated that also, madam.
And it was clear in the court.
Yes. We are quashing it.
Grateful.
Yes. Now you want to say something?
No, madam, if your lordship, I'm sorry, madam, if your lordship last time wanted me to reply anything is there in response to the counter evidence.
Why you were interfering? We were simply asking him what is his explanation.
Yes, madam. And that explanation, only one small submission with your lordship's permission. They rejected, my lord, on the ground of recommendation of the departmental technical committee. But here the technical committee is headed by the very same person, my lord. He is a member of that committee. He gets it approved. Report is made by the committee, and he is the chairman of that committee. On the next day, my lord, he accepts that. His own report.
The fresh tender, he has already given a clarification. Consider it again. And give a vividly. If any document is required, he will produce. Yes. Three, I think somebody was asking for an adjournment.
On behalf.
Whereas,
Item 48, right? Only I am concerned. Item 48, only the administration. You take care of.
I think we requested you to mention at the time of rising.
We are in 31. Yes.
Your Lordship, the CMAPL was filed for the CMAPL number.
What is that?
Your Lordship, that was filed for your restoration.
What is that?
Civil miscellaneous appeal.
I understand, but what is the nature? I do not know. I am not very accustomed with CMPL or like that. Can you tell me what is the nature of the application? What was the application?
Your Lordship, the application was for restoration.
Restoration. Say that you filed a restoration application. Then?
Your Lordship, that the application was filed along with an I for the condemnation of bill of 20.
Yes.
2096
2000?
days.
Okay.
Your Lordship, the I was rejected by the Honorable Single Bench.
Yeah.
And accordingly, the CMAPL was also dismissed.
Sure.
Your Lordship, the RSA, the second appeal was dismissed for non-removal of defects, not on merits.
Non-removal of?
Defects.
Okay.
Your three defects.
What you were doing? Why you did not?
Your Lordship, the London counsel for the second appeal, who was appearing in the second appeal, did not intimate about the dismissal of the second appeal, for which they could not prefer the restoration appeal within the stipulated period of time. That's all, ma'am.
It was a party there. OPS.
Your Lordship, the dispute was between the private parties.
Where is the judgment of the Supreme Court? 83 or 82 Supreme Court?
This has a compilation of judgments which are cited in the petition.
What?
The judgments which I have cited in the petition, I have a compilation of those judgments.
No. What for? What that judgment says?
Your Lordship, the judgment says that Your Lordship, the civil procedure is really the rules of the natural justice which are set out in great and elaborate detail. Its purpose is to enable both the parties to get a hearing. At least, Your Lordship, the parties may get a hearing on merits.
What?
The party get a chance of hearing on merits.
Food prevents, but then why the Order 9 Rule 9 is introduced in the codicil procedure? If that is the rule, then it should not have been introduced in the codicil procedure, Order 9 Rule 9, Order 9 Rule 4. Why it is introduced in the statute book, conferring power upon the court to dismiss it for default.
Your Lordship, the matter may be considered liberally as the RSC was dismissed for the non-deliverable.
Can we ignore Section 3? Section 5 you are talking about liberally, but what about Section 3 of the Limitation Act?
Your Lordship, the appellants are also willing to pay the cost because the land.
Oh, then you can buy the order. That is what you are saying, that you are ready to pay the cost. That means you can buy the order by paying cost. Is it a law? Where is the judgment I wanted? There is one judgment of the Supreme Court. Are you aware?
Get ready with that judgment.
There also, the appeal was dismissed for default for non-filing of the paper book. Then the court says that this cannot invite the dismissal of an appeal. Court should not. These are all the procedural part of it and not a substantive part. Similarly, removal of the defects is a procedural part of it. Bring that judgment, probably 83 or 93 Supreme Court. From Calcutta High Court it went up, let's say, rules of the Calcutta High Court, find out that judgment. First you affect the service. Who is appearing for the other side? The service will be better, huh? Service.
Yes, notice. I don't know that.
Come with that judgment.
Item 32.
What? 2 weeks. Not a 2 weeks.
Item 33.
My lord, please, it's impossible.
Why, madam?
Our senior will.
Who is the advocate at record? Are you?
No, madam. This is Nagadivan will appear for that.
You have been served with a copy?
Just now.
Huh?
Just now. Sir, the copy, please. Let them start now.
Here I notice that the grounds are longish than the petition.
My lord, I request, I am appearing for the appellant.
We should be that side as respondent.
True. That's what I was really confused.
Taken, I thought I'd not. Probably my learned friend here.
She came and appeared actually. Is there any?
My lord, I request that the matter may be
Mr.
passed
Singhvi, on a
on.
lighter note, is there any superstition?
No, it's just your lordship rules. Because I believe your lordship will otherwise mix up as to who the appellant and respondent your lordship.
Yeah, I just thought
That's
superstition.
convenience of the court, really.
Superstition sometimes comes on a right side or a left side.
Incidentally, well, it's
There was an.
completely. For a judge who has been in different courts, you will not know which side is petitioner, which side is. In Supreme Court, for example, it's strictly not followed. You can stand on either side. Although now courts have put up the old days. For a judge, it's difficult to know which side.
Capital also, on that table, if an appellant, the respondent it is given. So somebody know, but there are past incident there, superstition that say the wrong way.
They're seeking a password and nothing to say except that this judgment is of 22/6/26. And it is
22/5.
22/5, sir, 22/5/26 and listed now for the first time in August, 3 months later. And no
Suomoto case means? What is the Suomoto case?
No, but this is the point. I don't want to take time. I'll just give it actually in 2 minutes, literally. without opening paper.
No, I find from the purchase.
It's a CCI appeal.
Suomoto case number 2 of So that's why I asked, why suo motu? What is that suo motu?
There is a power to take suo motu
No,
cognizance.
no, I understand.
But DG, the thought point here is, there is no direction to the DG by any application of mine by the CCI to do an investigation. And the Act, unlike the old MRTP Act that we were brought up in the MRTP days, the DG cannot do anything suo motu. Now here the only single document they rely upon is 2021 minutes, which are what is dated 23rd August 2021. That minute has nothing by way of application of mine to direct an investigation. So the 26(1) statutory requirement of prima facie opinion, there is a section my Lord knows well, 26(1), is not fulfilled.
Competition Commission. This is the first time the matter has come. Which item?
No, this is 33.
33, yes. I find it the Competition Commission of India.
Yes, that is the appellate.
Okay.
Their order has been squashed as not satisfying 26(1), which is covered by CCI versus SAI. Anyway, whether I don't want to, Lordship may decide what to do.
My lord, we are being led by Miss Madhvi Diwan. My lord, I am requesting for short passover, my lord.
Where is he?
My lord, she'll be joining
She
shortly.
has some matter. She is in BC. She is in BC. She will appear in BC.
No.
A Madras High Court order, which has been completely misunderstood by treating it as a mandamus. The order said, please take action according to law. Everybody understood it to be that. But in that counter, they say no, it's a mandamus. It can't be a mandamus under 26(1). You have to form an opinion. You are CCI. So you have to form an opinion whether a DG should investigate. That can't be a mandamus by the High Court. It's not. The language is very clear. That is one of the fundamental errors. It's just automatic.
Oh, the first question was the order of the Madras High Court can be issued as.
Okay, that's the first issue.
30, I believe, frames the issue. On the text itself, there is no question of mandamus by lordships in Madras High Court.
Has to be a reference from
Yes.
authority.
Which is not the case.
The commission has to form an opinion.
There exists a prima facie case.
To direct the Director General to call an investigation.
In fact, the whole case will then can be decided by those two lines. This is the Honorable Chief Justice is reading. And the 23rd August 21. Well, as this whole thing which your Lordship has read is the crux of the matter. If on this,
The section was quoted, I just read it.
yes,
It appears
now
from
if you
there.
keep this section open and just see one document, only one in the whole case, the 2021 minutes, there is no application of mine. Their whole case is only on one
Where is
document.
that?
Yes, that is at page
Page 84
84
of the writ petition.
in the writ petition itself. Original rate.
Let's tag to the.
It's an extra E in your lordship's paper book. It was, sorry, P3. It's page 84.
Oh.
No, in your writ appeal paper book, in the today's paper book, it is page 84. Well, the writ appeal today, I'll tell you, allow me. Writ appeal today is 909.
So that is a part of.
It's an X. It's an
84, you are referring to judgment.
No, 84, I am referring a page number of the writ appeal paper book. Of the writ petition paper book, I'm sorry. Of the writ petition.
This is a part of the judgment.
It's not.
Page 84. 84 is a part of the judgment.
No,
The judgment is
no.
from 62.
Yeah,
page
apparently,
62 till,
yeah.
102.
Yeah,
That's
yeah.
what it is.
Apparently, that is the paper book my lord is using of the writ appeal. I am referring to page 84 of what my
Writ petition. Scale. The writ petition. They have annexed the writ petition. Petition to.
It is put in an e-file separately, I am told, tagged to your lordship's e-file. P3, correct. This is the totality of the prima facie case finding which your lordship requires under the Act.
Put it on.
11th August 2021. Sorry, 23rd August 2021. Letter dated 16th August of the DG and the order dated so-and-so of the Madras High Court. With the permission of the chairperson, an urgent special meeting of the commission was convened virtually on 17/8 on the subject cited. Virtual convening. Then the names are given. The decisions of the commission subsequent to detailed deliberations are as under. The secretariat is directed to register and number and convey the same to the DG. That's it.
DG to investigate the matter.
Yes. So prima facie opinion, reasons for the prima facie opinion, the very existence of a prima facie opinion, the language of the act, nothing. And see the Madras High Court order, just see that page. Previous page. Just see that. I mean, your lordship would never give a mandamus, but just see, is there at all a mandamus issue? Page 82. 80 and 82. Just come to 80. 80. It's a 482. It's very important. It's page 80. By CBI, yes, correct. By Malas, two respondents are involved, and there is a welfare association of the petitioner. Criminal original petition to register the case on the complaint given by the petitioner. I hope I'm clear on this. Now, this criminal, etc., I'll ignore. Come straight to para 3. Next page. It has been further submitted that most of the steel companies own house, despite no increase in labor and power, they've increased the steel prices. The steel companies, namely Tata, JSW, SAIL, Vizag, Tirumala, Kamachi, Agni, Indrora, Iskol, are involved in criminal acts. Now note, I'm not there. There are 9 names. I'm not there. Number 2, please note, the investigation is only about Tamil Nadu. Para 2 makes it clear it's only about Tamil Nadu. Well, on the top of para 2. I don't exist in Tamil Nadu. Now, having identified 9 people and limited to Tamil Nadu, they come to para 5. When the matter came up on the previous occasion, learned public prosecutor sought for some accommodation. Then 7, today public prosecutor says necessary action. Since the complaint dated 6th of March has already been forwarded to the DG for taking necessary action, as CBI has no jurisdiction. So CBI simply posts it to the DG. Just that. No action, and the DG can do nothing under the Act. Now come to 8. This is the entire judgment. In view of the above, as the said complaint has already been forwarded to the DG by letter dated 30th of April for taking necessary action, the DG concerned is hereby directed to proceed further in this regard and take necessary and appropriate action on the complaint filed by the petition in accordance with law. Now, the SOR of the Act says that the DG has no power to do it himself. Only the CCI can do it.
So according to you, this is really an order under section 482 of the.
Saying that if there is something in law, you follow 26(1).
Exercise of power under Article 226 in that sense.
A. No, not admittedly not. The lordship has read the order. Secondly, it is a direction to act in law. Law says you go under 26(1). There was an MRTP Act in the old days. It allowed the DG to take so much. Now there is an SOR, the Statement of Objects for this Act, which I quoted in my note, Wallace. Don't trouble yourself. Page 81 for you. Wallace, it says the DG would be able to act only if so directed by the Commission, but will not have any so motu powers for initiative. The SOR says. Got it here? Don't say this. Don't say it.
My God. Now the senior has come.
Oh, yes.
Now your senior has come.
Yes.
Yes, please.
Yes.
Ma'am, kindly unmute.
Yes, I'm grateful. My lords, I'm sorry I could not hear my lords, so perhaps the learned court master may adjust the mic, but of course I could hear my learned friend Dr. Singhvi. My lords, I'll just give an overview on this case, which, my lord, the learned single judge's impugned order.
No, madam, you were not there. And
Yes.
we had a privilege of going
Yes.
through paragraph 30
Yes,
of the
13,
impugned
my lords.
judgment,
Yes,
where the single bench has framed certain questions
right, my lords.
to be answered.
3-0, yes, my lords. Yes.
So it was really 5 questions
Yes.
that was framed to answer.
Yes, my lords.
So
Yes.
I think everything is squeezed into a very limited contour.
So, yes.
It says that whether the DG or DI, I do not know, district.
DG,
What
my
is
lords.
the
No,
DG?
it's a Director General, my lords. It's
Yes,
a
Director General has a power under the relevant act
Yes.
to conduct suo motu, the investigation. This is
Yes.
what it says. Second
Yes.
is that when the CCI recommended or forwarded, whether there was any formation of an opinion by him
Right,
from the document which is reflected,
right.
which according to section 26(1), according to them, is not
Yes.
by us, according to them,
Yes.
is a imperative one.
Right. So, my lord, I'll address your lordships on that. So, my lord, essentially the questions are really around section 26(1) and the scope of it in the peculiar facts and circumstances of this case. Now, my lords, just to give your lordships a little background, because there are 2 high courts, both the Madras High Court and before that, the Calcutta High Court, in this very larger investigation, which is investigating into a large steel cartel, my lords, which is across the country. Both the Calcutta High Court in the Sham Steel case, as well as the Madras High Court in the Agni Steel case arising out of, as I said, the larger investigation in this very case, have taken the view, because other members of that cartel had also made these very challenges, that there is no section 26(1) order, or it is not a valid order, and therefore you cannot proceed. So this question, my lords, was already answered 2 separate cases, one of which, my lords, travelled up to the Honourable Supreme Court, and, my lords, it was dismissed in our favour. So, my lords, insofar as 26(1), and I will have to take your lordships a little into the background in which it happened and the scope of section 26(1), so that your lordships are able to appreciate what has happened in this case. It is important, my lords, because what is happening, and that my lords, I think Dr. Singhvi is there for that reason, that, my lords, this order, which is contrary to and in the teeth of various judgments of the Honourable Supreme Court generally on first principles of competition law, or, my lords, as I mentioned, in Agni Steel and Sham Steel, which are cases relating to this very investigation. This is this learned single judge's order is in the teeth of these very judgments, which I shall show, my lords. Now, my lords, please bear this at the back of your minds, that given the fact that, and this is well settled law in competition, that these proceedings are in rem. They are not in personam proceedings, particularly because we are talking a cartel. This particular cartel of steel manufacturers, so far we have, my lords, about 31 or 32 parties, my lords. There are several parties who are located in different parts of the country. And when there is, my lords, any order which is passed, for instance, my lords, here when Calcutta High Court my lords, in May 2023, more than 3 years ago, passed an order upholding the 26-1 order in this very case and said, yes, the investigation must go on. That was also in respect of a that was not originally named by the original, my lords, informants or complainants. Now, my lords, when such an order has been passed in 2 cases upholding the 26-1 order, and the matter has proceeded, my lord, much progress has been made in the investigation. The investigation is in fact by the DG. It is over. Now, my lords, parties will be heard before the CCI. There is no adjudication at this stage. And I must therefore explain the scope of 26-1. But the preliminary point which I'm making here is, my lord, the learned single judge would be bound. Of course, he is not, my lords, he is not bound by orders of other high courts or judgments of other high courts. But one, it would have persuasive value, and 2, my lords, in view of the committee principle, that ultimately, and particularly when it is an in rem, when an order, my lords, passed 3 years down the line after the 26-1 order has been upheld by 2 other high courts and upheld in one case by the Supreme Court, my lords, to then pass an order which is in the teeth of such findings by 2 separate high courts. This is a case of forum shopping, unfortunately, and I will show that. They had, my lord, the searches and summons, etc., were conducted on this original petitioner in Calcutta. It was not conducted, my lords, in Orissa. They chose to go to Orissa because, my lord, it happens very often, and this is something to be guarded against, that in cartel cases, when you have so many, my lord, maybe dozens of parties, they ultimately, what is a cartel? Because they are all acting in concert. One will take a chance in one high court, another will take a chance in another high court, the third, and somebody they hope will get lucky. So that is what has happened in this case. And, my lord, the timing of the order, your lordships will see 3 years later in 2025, moves after complying with all the summons, the search and seizure operation, all of that takes place. It culminates in an investigation report. That investigation report has been put before the CCI. Now parties will be heard on their objections. Natural justice will be followed as is required under the scheme of 26 and as upheld in the sale judgment by the Supreme Court, and only then will an adjudication take place. So no adjudication has taken place so far, but the attempt to derail, my lords, with great respect, the learned single judge ought not to set this, and what he has done, my lords, most respectfully I say, is in the teeth of various judgments also of this court. So, my lords, just bear that in mind, that there are already 2 high court judgments, including one in the Calcutta High Court, where similarly placed a party who was not originally named, but he has been subsequently joined, Sham Steel. He is also, my lords, part of the investigation. In his case, 26-1 was upheld. And 26-1, my lords, the order is a common order. They are not separate 26-1 that, oh, you investigate X, now you investigate Y. It doesn't happen like that. It is a common order, and then it goes to the DG. I'll show that under the scheme. Your lordships will have to see that. But under the scheme, under 26-1, my lords, the DG is directed to conduct an investigation. He conducts the investigation. He may find many more parties, as is, again, this is also settled, that he is free to join more parties, etc. At that stage, whatever, depending on what he finds in the investigation, then he prepares a report and he puts it before the CCI. So I just want to now, my lords, with that preliminary point, and then I'll take your lordships through what Calcutta High Court has held in.
Why the single bench has allowed the writ petition?
Yes. In my respectful submission, it is number one. The findings are, number one, that there is no 26-1 order at all in this case, that it is a jurisdictional defect, which is again contrary to and in the teeth of what the Calcutta High Court has held and what Agni Steel has held in the Madras High Court. Madras High Court, my lord, travelled up to the Supreme Court, and, my lords, was dismissed in our favour. So, my lords, in our respectful submission, that issue, that ship had already sailed as to what a 26-1 order in our respectful submission became final. Yes, it was acted upon, investigation took place. This particular party also appeared, my lords, pursuant to there was search and seizure operations which were conducted on them. There was summons issued to them, and belatedly they come, my lords, in September 2025, and they filed their writ. So, my lord, number one finding of the learned single judge is that there is a fatal error. There's no 26(1). I will address that, my lords. There is a very, very good explanation which has been dealt with both by Calcutta High Court and by the Madras High Court in Agni State. That is number one.
Both are a single bench decision. What I find, Calcutta.
My lords, Madras is not. Madras is division bench. My lords, in any case, your lordships will see
you are correct, because
yes,
so far as the Madras High Court's judgment is concerned,
it's division.
It is only have a persuasive value so far as we are concerned.
Absolutely, my lord. I cannot. Yes.
But I find the name of the single judge. That's why I'm thinking. I don't think so. It's a division bench.
My lord, Madras.
Madras is a single bench.
Madras, no, my lord, Madras is, my lord, the learned Chief Justice there, and my lord, it's a division.
CORAM is the Honorable Mrs. Justice such and such.
No, my lord, that's a different order. That's an earlier order in a slightly different context. I'll come to that. But no, that's not the order I'm relying on, my lord.
Okay, so that is what the other side just draws our attention to it.
I'll address that, my lord. I'll address that.
Anyhow, yes.
Yes. My lord, just to give your lordships, my lord, I'll require a little time, so please bear with me. But my lord, section 26 of the Competition Act, and I will take your lordship through that provision. It's a very, very well, my lord, deliberated, well structured, but self-contained provision which provides the procedure for an inquiry into what, my lords. It may be anti-competitive agreements. It may be into cases of dominant position. I'll read the section later, my lords. I'm just giving your lordship broadly what it is. It's the procedure which is set out. Now, that procedure may culminate eventually. It may culminate in a penalty at the very end of the when everything is concluded. Application has made. It may may culminate in the closure of the case also. Either which way may happen. But, my lords, most of these cases have been involved at the stage of, my lords, 26 subsection 1, which is the very, my lords, preliminary trigger point. It's a very, very preliminary trigger point, and I say this carefully because this has been very well, my lord, settled in a very detailed judgment of the Supreme Court in the Sale case. In Sale, my lords, what the Supreme Court held is that this prima facie case that has to be made out prior to directing investigation by the DG is a very, very preliminary threshold. No detailed reasons need to be given. But there is a very threshold opinion, and thereafter, my lords, the adjudication takes place at a much later stage. Hearing is not to be given. Notice is not required to be given at the stage of 26.
No, definitely not. Definitely not. But what I understood from their stand is that formation of an opinion is not a mere idle exercise.
No, correct. Now,
there should be some conscious application of mind.
Yes.
And that should be reflected somewhere in the in a more extensive or a lucid manner, but at least some, the semblance of some ground, some opinion that should also be there.
Right. So fair enough, my lord. Your lordships are absolutely right. I want to now point out, I'll just complete the little sequence of 26.
So the Supreme Court has definitely say that definitely formation of an opinion. It does not say that there cannot be any opinion at all.
On the contrary, my lord, what I want to now indicate to your lordships is peculiarly what happened. So, my lord, just bear that 26(1) minimal opinion, yes. Prima facie case, then the ball is set rolling, the direction given to DG to investigate, then there is a report by the DG then sends the report to CCI may order further investigation, or it may then call for objections and suggestions. It may even close the matter in the meanwhile if it feels that there is nothing to it. Then after hearing the parties, if it feels there is something, it may eventually culminate in an order after hearing the parties in a penalty or closure of the case. That is broadly, my lord, broadly the 26. Now, in this particular case, what happened was this. My lords, please bear one thing in mind also, that CCI and DG are two distinct entities under the Act. Their functions are different, their roles are different. I'm coming to that. I'm coming to that, my lord. Now, my lord, what happened in this case? There was a contractors association who moved the Madras High Court. That's the first order which my learned friend relied on and which your lordships have, I think, been shown, at least part of it. Now, what happened there was this contractors association, who are, my lord, who are contractors association, they are consumers of steel. Now, what they said was that this is absolutely, there's a criminal syndicate by steel manufacturers, and we were not parties, my lord. Neither DG nor CCI was a party to these proceedings. Now, but they filed this criminal writ petition. They said that CBI must investigate. And they said that, look, there is this criminal syndicate. They have raised prices to some 55%. We are being exploited, etc. There's anti-competitive conduct, etc. So, my lords, when the CBI, the special prosecutor, was asked to take instructions, and he came back with a letter saying that, look, we have already written to the Director General directly. My lord, they didn't write to CCI, they wrote to the Director General. And they said that investigation should be conducted. They brought that letter to the court. The court records that. And exercising its inherent power, my lords, it was under 482. And exercising its inherent power, the High Court thought it fit to direct DG to take the necessary action. Now, something turns on this, because DG and CCI are distinct. So, my lords, please see what has happened. And my lords, the Calcutta High Court order, your lordships should look at the reason, because it's going to throw some light on this. We have argued this issue and we succeeded on it in that round in 2023. Now, my lords, what happens here, and may I just show that order again to your lordships, the order of the Madras High Court dated 29/7/2021. Your lordships may see that at page 30. Well, there's a compilation of documents which we have filed. It is at page 37 of that compilation. Because, my lords, this is important because this was by virtue of a judicial order that the DG, not CCI. CCI is the one, your lord,
which was there in the writ petition, same order you are referring.
My lord, I take
same order, I believe.
Yes, it was, but it is part of our compilation. It is part of our compilation at page 37. 37.
Yes, we got it. Yes, same order.
Yes. So, my lord, this is by a learned single judge. And your lordships will see the date is 29/7/2021, which is where, my lord, everything originates.
Yes.
Now, my lords, just very quickly, I'll show your lordships a little bit of para 2, because your lordships will see the allegations against the steel manufacturers, and about 8 lines, my lords, from the bottom of para 2, they say, while so the steel manufacturers forming a syndicate for profiteering resulting in 55% hike in steel prices, steel owners during the past 6 months making project unviable. Further, steel companies have hiked price by 2,500 rupees to
No technical glitch. Madam, we can't hear you. We can't hear you, madam. Madam, we can't hear you. Technical glitch is going on. The technical glitch.
Both flat and long products for December on the back of rising iron. Yes. I'm so sorry, my lords. This network. I'm trying, my lords. The network. Yes. I'm so sorry, my lords. Please connect to the phone.
We could not hear you what you were saying, referring this judgment of the Madras.
I'm sorry. Yes. Can my lords hear me now? Can my lords hear me now?
Yes, yes.
Yes, I'm so sorry. So now, my lords, please, so therefore, my lord, they made these various allegations, including at para 4. And then,
No,
my
you were
lords,
referring paragraph 2, I think the
Yes.
lower portion.
yes, the lower portion, what I was just referring
You
to
say
is,
that the price from 2,500 to 2,700 per ton.
yes. So,
Of
my lord,
both flat-
basically, yes, the allegation, my lords, against the steel manufacturers who are part of this alleged cartel was that they are simply exploiting the consumer and they have recklessly raised the prices. That was long and short of, my lords, and it was a functioning as a syndicate. Now, see, please see at para 3, for instance, they have talked about, they've named certain parties and they have said that this is being done for illegal gain to fix steel prices in the market. And these companies manipulate in such a way as to cheat not only the government, but also for illegal profit. Then, my lords, again at para 4, they mention these anti-competitive activities which are taking place. Then, my lords, 5. It is marked as para 5. It says, when the matter came up on the previous occasion, i.e. 15/4/21, the learned special public prosecutor sought for some accommodation to get instruction and the matter was posted on 4/6/21. Today, the learned special public prosecutor has produced a letter dated 25/6/21 in reference so-and-so, where it is stated as follows. Since the complaint dated 6/3/21 of the petitioner has already been forwarded to the Director General Investigation, Competition Commission of India, New Delhi, vide letter dated 30/4/2021 for taking necessary action as CBI has no jurisdiction to take up the matter. Hence, the Honorable High Court may be apprised accordingly. Now, my lords, this is very important, para 8. In view of the above, as the said complaint has already been forwarded to the Director General Investigation, my lords, please note this. It is directly to the Director General Investigation, which is distinct from my functions as CCI. I'll show that. But please note, it's forwarded to the Director General Investigation, Competition Commission of India, New Delhi, by letter dated 30/4/21 for taking necessary action. The Director General Investigation concerned is hereby directed to proceed further in this regard and take necessary and appropriate action on the complaint dated 6/3/21 filed by the petitioner herein in accordance with law within a period of 4 weeks from the date of receipt of copy of this order, and the criminal writ petition was disposed of. So, number one, this was the High Court exercising its inherent power, number one. Number two, para 8 notes there is a direction directly to the Director General of Investigation to do the needful, to take necessary action. Now, my lord, this is very important because there is distinction in the status, functions, and powers of the Director General on the one hand and the CCI on the other. See, of course, Director General, my lords, is under the CCI because it is the investigative wing in that sense, but its functions are not to pass an order under 26(1). Its functions are to conduct investigation. So, when the High Court, and I will show this from the sequence of section 26 also, when the High Court in inherent power passes a direction against the Director General Investigation to take necessary and appropriate action, it means, as we understand, and as the High Court of Calcutta has also held, that it means do what you are empowered to do under the Act, which is to carry out investigation. Now, I'll show those sections, my lords, what a Director General should do. So what has happened in that, because there was a direct, my lord, the High Court in that sense bypassed the CCI. The CCI, it did not say, it could have said, but it did not say, again, it's low bandwidth. it did not say, it could have said that, look, we are directing CCI to look into the matter and take a decision in the matter. It did not say that. It said, you, Director General, will proceed and take necessary action. It was a direction. It was not, didn't say, oh, you consider whether you should do or you shouldn't do. Nothing of the sort. Director General to take necessary action. Now, my lords, the Director General has certain powers which are not powers under 26(1). Director General can only investigate and do whatever he needs to do for the purposes of investigation. So that stage, I want to show from section 26, that stage of 26(1), in a sense, my lords, was either, your lordships may say, eclipsed by virtue of a court directive. Or, my lords, it could in that sense be subsumed. Because, my lords, I ask myself one question, because your lordships will see 26(1), your lordships will also see 26(2). If I had stepped in as CCI and said that now I am going to consider whether to issue a specific direction, and because, my lord, when I have the power under 26(1) to form a prima facie opinion to direct investigation, I also have the power to close the case and say there's nothing to be done. I have both the powers.
This is inherent and ingrained. If you have a power to do it,
correct,
then it is implied that you have power not to do it.
So yes, and my lord, that is also statutory. If your lordship sees under 26.
Yes, I have seen the language of both the 1 and 2.
Yes. So, my lords, I ask myself this question, and this is what we had argued before the Honorable Calcutta High Court. Look, if the direction was to, if I was to exercise my powers one way or the other under 26(1) or 26(2), could I have stepped in, circumvented the High Court's direction and said, no, DG, you wait. I am going to decide as CC, I'm going to take a separate decision. I may take a decision to close the case. My lords, I ask myself one question. Would that not have amounted to interdicting or circumventing the High Court's direction? So, my lords, nobody challenged this order. Nobody, whether the steel manufacturers or anybody else, challenged this. And in this order, my lords, effectively, my lord, one may look at it two ways. We did pass a formal order saying, look, suo moto, we are, because, my lord, this was an unusual case for us also, that the court has stepped in and is passing a direction, because it is obviously persuaded by something that the that the consumers, that is the contractors, had argued before the High Court. We were not there. And we found that there is this order directly telling the DG that you please investigate. So we passed a formal direction. We did pass a formal direction, and that has been upheld even Madras High Court. My lords, I will show your lordships both those orders. In Sham Steel, the Calcutta High Court takes the reasoning that I am trying to articulate before your lordships, which is that it effectively got subsumed. And when that happened, there was no question of going back and saying, we are going to consider whether or not to do this, whether to form a prima facie opinion. You don't need to do that. That process, for instance, my lord, there are cases where when the court steps in, the Supreme Court has stepped in so many cases, direct CBI investigation, then the sanction is not required separately. So that is, my lords, the nature of the case. That's number one. Number two, my lord, Agni Steel, Madras High Court's reasoning in the division bench judgment is a little different. They say, no, it's sufficiently reasoned. It falls, it satisfies the parameters of 26(1), and that was, my lords, if the steel manufacturer there, Agni Steel, challenged it before the Supreme Court and lost. So, my lords, therefore, this question of 26(1), whether it is passed or not, effectively was a closed issue, and it was acted upon, particularly, my lords, when we have multiple parties, multiple members of the cartel, and new members may be discovered during the course of the investigation. You cannot say then that you have to have separate orders of 26(1) in every case. That would, my lord, be a travesty of competition law, and the interest of the consumer would be destroyed in the meanwhile if we are to go back. What does happen, my lords, typically in a lot of cases that we are seeing, my lords, that before different high courts, different members of the cartel, who are, of course, they probably acting in concert there also, they say, you take a chance here, I'll take a chance here, and the third person will take a chance elsewhere. Somebody gets lucky, So, my lords, you get some order. And that is, my lords, here belatedly 3 years down the lane, they tried their hand at this. And we are sorry to say that they succeeded before the learned single judge. And I have a lot more to say, my lords, about what the manner in which the learned single judge dealt with the issue. But, my lord, before that, may I show your lordships both sham steel and agni steel? And in our respectful submission, given the principle of comity of courts, given the interrelationship in a cartel case between all cases, the learned single judge ought not to have taken a different view. My lords, please see sham steel in the compilation. It is at page 1 of the compilation. That is an order of 18th of May 2023. My lords have that?
Yes, yes, I'm looking at the sham steel.
Yes, my lord, may I read from paragraph 4, please? Because your lordships will be able to appreciate that argument. And also, please see para 3, because we did, my lords, we did direct as a suo motu case. We did pass an order, also a formal order under 26(1). Para 3, the petitioners are aggrieved by the summons and seek quashing of the same. The petitioners pray for interim protection from suo motu case number 2 of 2021 and the impugned summons dated 13/4/23. Learned counsel appearing for the petitioner submits that the impugned summons was issued without regard to the statutory mandate under section 26(1) of the Competition Act. My lord, exactly the same argument. Counsel submits that the requirement to form a prima facie opinion on the commission must be fulfilled before the Director General can be directed to cause an investigation. Counsel refers to an order of Madras High Court dated 29/7/2021 in Coimbatore Corporation Contractors Welfare Association versus CBI, what your lordships have just seen, whereby the court directed the Director General to act in accordance with law. Counsel submits that the first petitioner was not named in the Madras High Court order and that the decision dated 23/8/2021 of the Commission directing the DG to investigate the matter in terms of the said order was made available to the petitioners only on 21/4/2023. My lords, pausing here for a moment, this is also identically the issue here. They've also raised this point that we were not, this original petitioner says, I was not named in the order, in the original order. It is submitted that without recording the prima facie opinion on the existence of a case against the petitioners, all subsequent assumptions of jurisdiction are a nullity. Then, my lords, these were our arguments. The learned ASG appearing for the Competition Commission of India seeks to defend the investigation and the impugned summons with reference to the framework of the Act. Counsel submits that the DG did not have any choice after the order of the Madras High Court but to conduct investigation into the matter.
This is where the crux lies.
Yes.
So now the crux lies that
yes.
Once the court has already directed the DG to make an investigation,
yes,
there is no option left to the CCIs to take a contrary route.
Yes.
That so, my lord, the Calcutta High Court has also said that section 26 and 41.
That's right.
Are a very distinct and different and separate.
My lord has read
the powers are separately exercised.
Correct.
And then it says that once the order is passed, there is no other option but to go for this.
Yes.
So it has got nothing to do so far as the CCI's obligation in forming an opinion is concerned. It has simply proceeded on the basis that once the court has directed the DG to continue with the investigation, there is no option left to anybody.
So that's the point, my lords. In this case, that is the very point. And I'll show Agni Steel also takes a different reasoning. But this is the point that could the CCI, they are saying that CCI has not formed a prima facie opinion and passed a separate order under 26(1). And therefore, the whole thing is a nullity. My lord, I ask myself, in the peculiar facts and circumstances of this case, and this is the common case, it's ultimately a common case, it's a common investigation. We could not have done that. So that is the point. We could not have done that because the court interdicted that process in any case. So that is one way of looking at it. And therefore, there was no requirement for a separate order. If your lordships just sees para 13, my lords, it says, my lord, the words are very, very important. Para 13, the complaint alleging anti-competitive activities controlling supply and of steel and creating artificial scarcity of steel through the concerted actions of steel manufacturers causing artificial increase in the price of steel within the purview of sections 3.1 and 4.1 of the Act, which in turn forms a substratum for an inquiry under section 19 and catalyzes the procedure for an inquiry under section 26.1 of the Act. Therefore, the Madras High Court order, my lord, this is the 21 order, compresses and subsumes the sequential steps for the Commission to inquire into any alleged contravention on receipt of any information or information received under section 19 or on its own knowledge of such contravention. The order, in essence, kickstarts the process from the stage of directing the Director General to cause an investigation without exhausting requirements preceding the Commission's direction to the Director General under section 26.1 of the Act. So, my lord, I'm going to show your lordship's Agni Steel, and in my respectful submission, this is an appeal which requires to be considered. My lords may consider, because if there are two benches which have in the very same investigation taken a different view, my lords, the learned single judge ought to have deferred to that. And in this case, there was no choice. If I could not exercise my my power under 26.2, I could not have exercised.
What do you say two benches means?
Well, two benches means one is Agni Steel Madras High Court, which I have not read yet to my lords. The second is Sham Steel Calcutta High Court. So therefore, this therefore requires consideration, and your lordship may consider putting it down for hearing on an appropriate date. I'll just show your lordship's Agni Steel and then the Supreme Court order in Agni Steel. Page 4, my lords, page 14.
I think the matter is at a very, 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 I would say, threshold, dependent upon the interpretation of the sections of the Competition Act.
That's right, my lords.
There is no difficulty on that. It does not require any factual aspect to be deeply gone into.
But the legal aspect,
the facts are very clear.
Yes.
There is two judgments that are there.
Yes.
Madras, Calcutta, there is already your letter for investigation that is there. Now we have to consider whether it is in conformity with section 26.1 or is not a conformity with section 26.1, or whether the Madras High Court judgment which directed the DG to continue left any option to the CCI to take a departure therefrom. According to you, definitely not, because the order of the court is to be respected in all sense by it.
Right.
So all these things are very apparent, I believe. I think only we have to decide the nuances of the law in this regard.
Yes, my lord, because there is a lot of case law on this, and my lord, we would like to put it before your lordship, including say there are Supreme Court judgments, and there are a few other points, my lords, other findings in the order apart from on 26.1 itself, which I will have to deal with. So, my lord, depending on your lordships, what your lordships feel, my lord, would your lordships like to keep it on a day for final hearing?
No, this is what we do is that if we find any appeal can be decided conveniently on the basis of the available materials and a pure question of law is involved, unnecessarily we do not really linger on the matter.
Right. So, my lord, in that case, my lord,
even at the admission stage, we decided inviting the parties to address. So, you want to argue, you are ready, then you can argue. There is no penalty. But if you want to argue on the other day, tell me.
Well, Lord, I would request that. I would certainly request that, because there is a fair amount to be addressed.
I believe that the point is very, 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 very small.
Lord, what will
within
happen?
a very limited contour.
Lord, there are about 4 or 5 findings on slightly different aspects. We are only on 26.1 right now, and 26.1 also I will have to take your lordships through, say, because the consequences, my lord, are very grave, because it means that an investigation which has fructified into a DG report after, my lords, about 4 to 5 years is now, my lords, they are seeking at the behest of one party to undo the process. So that has some implications. There's a comity principle, and 26(1) itself, in a case where the court interdicts, where is the question of 26(1), and apart from that, Agni Steel, where the court has taken a view that 26(1) is a properly reasoned order. So, my lord, these are the, I would like to address your lordships on this. Plus, there are some other issues, including there, my lords, being under the impression that they were third parties, which is a completely misconceived. The other aspect which has been gone into, and which I would address my lords on, at several places in the impugned order, what the learned single judge says is that there are reputational consequences and civil consequences when you conduct an investigation. That is in the teeth of several judgments, my lord, both of the one of the Supreme Court, and there are of the High Courts, which have said that, look, there is no question of any adjudication or any civil consequences or any reputational harm that can take place merely because summons are issued.
That will take, if some of the points which strikes at the root of the very competence of the CCI,
yes,
if that is decided first, I think
yes,
the others are really an ancillary or
my lord, your lordship are right.
from that.
However, my lords, these orders become precedents. They become precedents immediately, and competition law being a specialized field, my lords, this is doing a lot of harm to the cause of competition law, if we want, my lords, for the consumers. So at this stage in time, my lords, I need to show your lordship, because ultimately this was rich jurisdiction. The conduct of this party in coming to the court after having complied with the summons, after having been subjected to the search seizure operations without any demur or protest, my lords. Suddenly, after so many years, they come and they take an order where, my lords, the entire process qua them is sought to be derailed. So this will, and this order is being cited, my lords, and it's contrary to various division bench, my lords. In even the Amazon Flipkart case, my lords, the division bench of the Karnataka High Court held that there's no question of any reputational harm when an investigation is
there is
conducted.
no difference. It does not really create an stigmatic,
So, my lord, your lordships
stigma
would
is
have
not
to set
attached to
aside. Your lordships
is a
would
very
have to-
fair way of dealing in a competitive market, how to do it.
Exactly.
We appreciate the very object of the such enactment to be brought
Yes, my lord.
in the year 2002.
Yes.
That is we are conscious of it. But only thing is, if it's required to be done in a particular manner, it has to be done in
So,
that
my
manner.
lords, that is the whole thing. Could I have interdicted? And, my lord, what happens to Agni Steel? It's a common, my lord, it's a common investigation.
So we'll consider it. We'll consider. She wanted to make a extensive argument.
My lord, I do wish
She
to.
wanted,
I really do. I still need to address your lordship, even on the 26(1) point, but even the others, my lords, they are wrong. They are contrary to judgments of Supreme Court and the High Court, and therefore, my lords, I would like to address your lordships. As a regulator, I think this is important for us. There are far-reaching consequences, and we have something to say about the conduct of this party. So we will address your lordships on that.
Taking adjournment, simplicity, I can't.
No, I'm not taking, Dr. Singhvi, please. They are not taking adjournments like that. I can certainly argue, but there are other points to be argued as well.
Well, the adjournment can have different synonyms. Well, you can have 5 different synonyms for adjournment. But I am saying that
Since it is live, I can't express.
therefore, well, all I'm saying is that if the lordship is giving a date, the lordship will give a date. If they come after 3 months, even on the filing, the date is May of 26 when the impugned order came.
And in fact, I want to also
come
point
after
this
3
out.
months.
No, my lords, my lords, the matter
Right.
was argued on 8th
I
of
have
December.
already said, I have passed an order that whoever files, the moment the defects are removed, it has to be listed within 48 hours.
No, but
Or
we
maximum
also
72
take steps.
hours.
How much step did they take? Your
My
lordship,
lords, the judgment
we run
came
around all the
after
time and we
5
mention
and
to your
a
lordship
half
for listing.
months.
Nobody did anything for 3 months here.
My lords, the arguments had
What is happening
concluded.
here?
3 months.
That whoever files after the removal of the defect within 72 hours.
CCI is not bothered about this matter.
Was it defect sometime?
No, I think that's a very unfair remark to make. It's totally
Because from
unnecessary.
22nd
Totally
May-
unnecessary. I'm sorry, Dr. Singhvi.
22nd May till today, nothing has been done.
Now, I want to also point out, 8th of December, my lords, the judgment was reserved before the learned single judge. We were directed to file written submissions. The judgment comes on 22nd of May, and it records that the the hearing was conducted on
July
7th
was
of March.
registered.
On 7th of March, there was no
And the
hearing.
defect? Then why it was not placed before the bench within 48 or 72 hours in the July? This could have been done.
What defects were cleared quickly. I see.
What the department is doing? This day is convenient to you, but we'll finish it off.
Yes, my lord, but I will have to address the as well, because these are points which will hurt the CCI in other matters. And already, my lord, they have started using this judgment in other matters which are quite well settled and are where the investigation has been concluded.
I was making a request as a bit of an exception if possible. It's now been started, so it will not follow the lawsuit normal rule. If this can be on a Wednesday or Thursday, Sunday. In September, mid-September, Wednesday, Thursday.
Non-miscellaneous day.
Monday and Tuesday are now on
Monday and Friday.
Barring 11th to 19th September, I request.
Tuesday as well as a bigger miscellaneous day of a kind than Monday and Friday. Because these are those miscellaneous which are heard at some length and then, not fully.
Okay.
It's a fully miscellaneous. The Lordship will have it on 16th or my husband doesn't want prior to that.
No, my lord, 11th. Sorry, Dr. Singhvi, it's 11th to 19th of September.
Okay, very well.
Not
have it on 23rd.
I was thinking of the next week because I have already applied my mind, both of
Then, your Lordship may consider just the week thereafter, 3rd of May, 3rd of September.
we are on
Yes,
17th, so
3rd of September is fine. Yes.
3rd is there, Thursday.
Oh, we can do the 27th. Is good my lords? Will you suit my lords on the 27th?
27th is a good, that's why I was just thinking, either on
27th, then it's 27th.
Yes, madam, on 27th.
Very well, my lord.
Obliged.
Because this, please come with a compilation. I believe that prima facie, don't take it an observation from me or a bench. Prima facie, it appears that 2 or 3 points are really involved in this.
Yes, my lord.
One is the what should be interpretation of 26(1), any issue related to 26(1), which is there, and the third one is the second one is I think the effect of the judgment of the Madras High Court.
Yes, my lord. There is also
these are primarily 2 grounds. Now, question of DGs making a investigation against a non-party. These are all, I believe. I do not think.
But these are findings which are standing there.
I
and which
do not think that it will investigation when it is directed. An investigation is a open investigation.
Yes, absolutely.
Anyhow.
Yes.
So I think primarily 2 points, and both of them are really going into the root of the main matter.
Right. And in my lord, what is the effect of a high court in its powers, whether it's inherent powers or my lord, extraordinary powers?
Let us see the plenary jurisdiction, inherent jurisdiction. Let us see whether it is excises. Excises under section 482 or excises under article 226, 227, or whatever, let us see an
But
example.
it's, my lord, what has happened is that order became final. Nobody challenged it. So what is the effect?
Still ourselves for 27.
Yes, we'll do that.
It's 27th.
Yes, I'm obliged, my lord. Obliged.
After hearing the counsel for the respective
In item 34, my lord is saying that the departure is appeared in caveat.
So you have to
I
have a
also
copy.
have the soft copy of the writ appeal, but my lord is insisting on a hard copy. So if you
Ask me, associate
so if you're insisting
pay off. Pay the price for that. Okay. Photos. Yeah. Yes. Yes.
I will serve a copy
Today or tomorrow?
by tomorrow. Okay.
The counsel appearing for the opposite party. What? What, sir?
Mr. Malik, Malik is DG of the court.
Mr. Malik?
Yes, ma'am. On behalf of Mr. Malik. He's busy in other court.
Then come after a week, next week.
Item 36.
Yes, Your Lordships. Your Honor, the order of the Honorable Single Judge, Annexure
Please bring
1.
on.
Annexure 1 is under 7.
This is the original copy. What is the original copy? This is a printed, downloaded. They not filed the hard copy. We filed, so office printed. You are challenging an order dated
There is mirror 22/7/2026, page 17. It starts from page 17.
Give us 30 seconds time. Well, just. Opportunity is given to him. And why you are so?
But if you also look at that 2026 one.
Understood. What you say? He was already in custody. He was released from custody on 26 June. He immediately took out an application on 29 June seeking extension of time to file a reply. The time was up to 30th of June. The application was not there. Service, you can't blame the system or.
So they could have supplied a
Then you'll have to blame on your brethren fraternity. Why the litigant should suffer for such latches. And immediately on 1st July, you have already passed an order. Now the position, the court has taken a very lenient view that, look, 3 days was too scanty, yet he has already approached the court on 29th. It is not that he did not file an application on 29th. Maybe on 2nd July, he has served you a copy. On 1st July, you have already done everything.
No, I can see. When the initial order was passed, my lord, in last year.
$75 or 70? Order dated?
27/26.
27?
Yes, sir.
22?
27/2026.
It's a paid 70.
The third round of litigation.
Oh, there is a 2-2 order also. I got confused. It was the 2nd February. This is 2nd February. Okay, Mr. Bashi, who is appearing for the state? No, not paragraph. I am simply asking who is appearing for the state. You.
Yes.
You are. You are the answering respondent in the appeal.
Or VSS Medical.
It's medical college.
VSS.
No, you.
What?
Varla. Vimla ka Varla. What is this?
Burla.
Vimsa. You represent Vimsa?
Yes.
No difficulty? Yes, sir.
Not sure.
How you can maintain an appeal after the concession having given?
You know, sure what humble is somebody else.
Are you the same counsel?
No. Not sure what a humble is.
So once your client has given a consent that she will vacate by 15th, has she vacated by 15th?
No.
No.
Not sure what a humble is submit.
Immediately, what is the law on the subject?
Either you will vacate or the eviction proceeding will be initiated.
Yes. You immediately, and that will impact does it have any impact on the service? Misconduct, does it come within the purview of misconduct?
It will come. It will come. You also what a humble is submit. That instruction was never given by the petitioner.
Go before the single bench then, same judge.
Not sure. And finally,
It is, then law is very clear. Bank of Bihar's case.
not that day for liberty or whatever filing before some.
What liberty? That's we don't know. We don't know. 27. Law is very clear.
What is this limitation period of reached also?
If you say without instruction, then you'll have to go there. She has to. Then we have to dismiss this appeal. We have to dismiss. We will not say anything on that. No liberty, nothing of that kind. If it is permissible, go there. No.
You'll withdraw or not?
I'll withdraw. Withdraw.
This is by instruction.
I didn't remember that.
This is on instruction. On instruction. No application from other side, any other lawyer will come. Anyhow, give a memo.
No, 38.
The care first one.
Which order is under challenge, sir?
4/8/2026 one.
Or
At page.
just give us 30 seconds time to just
Page 11.
Page 11.
Where is the writ petition which you filed?
Annex 2 at page 13.
18643.
Yes, ma'am.
Where is it?
No.
This is 24592. Where it is?
Annex page.
Page 13. Where is?
There at page 44, ma'am.
You can't multiply the proceedings.
I could have filed my lord.
You
I
can't
could have
multiply the
filed my lord. I
proceedings.
could have filed the intended
Sorry.
application.
You have challenged the order of no confidence or termination, whatever.
Sub judice before.
So that is a sub judice interim order is there that
Yeah.
you can proceed, but you will not pass any final order.
Yes, fine.
That is there.
There.
Pending in which bench?
Before Honorable Justice forget once. I also tried this in my lord. My allegation is against the executive officer of the Belfast municipality. The executive officer of Belfast municipality is not a party to that no confidence motion proceeding. That MP. In that return, executive officer is not a party, my lord. When my prayer is against completing my allegation in the petition against the executive officer of the Belfast municipality, my lord,
What?
that he is not allowed to discharge my duty. Well, after that 24/6/2026, he is not allowing me to discharge the duty. Therefore, I cannot file the interim application in the previous writ petition, as the executive officer is not a party in that petition. Therefore, I filed.
Can you not implead the executive officer party there?
Because cause of action was not there, because that order, collector's order was there. Collector is the authority to give the notice for no confidence. Executive officer has no role to play there. Therefore, my lord, as cause of action arises after 24/6/2026, and the executive officer was not a party in that petition, therefore filed a separate. I cannot go and file the interim application in the no confidence motion actually against the executive officer. Therefore, I filed the petition. At present, I cannot file by the in that case. When a party is the executive officer is not a party, I cannot file an interim application for a direction against the executive officer. Only that is the separate cause of action, and against whom I am seeking the relief, he is not a party in the previous petition.
Are you not seeking permission to continue in terms of the interim order passed in that?
Only by when no confidence motion has not been passed.
I'm asking you.
No, I am.
Is it independent of the interim order or it is a dependent of the interim order? Your relief
Relief, my lord, when
is an independent of the interim order or dependent of the interim order?
it, my lord, depends on based on the interim order.
So then you go.
Based on interim order. On the basis of that interim order, my lord, I am seeking relief against another.
That means that despite the interim order, you are not permitted to join. So somebody who has intermeddles with the order, he may not be a party to the proceeding, but liable for violation.
Contempt because the result has not been published, my lord. The interim order that the proceeding may the no confidence.
According to you, the interim order is to be construed in such a manner that you may be permitted to continue.
Continue. That is
correct.
Yes.
So it is not dependent upon the final decision.
Yes. No.
So interim order is violated.
If interim order has been violated,
then we'll have to move.
Against the executive officer, my lord, contempt proceeding will lie or not. That is
why not, sir?
He is not a party to that.
No, sir. Then there is a
that given my lord. That liberty may be given. If contempt petition will lie, I will go for contempt.
There is already a Seawald principles are there in the law. Seawald principles are there.
That is why I will fight. Liberty may be given.
Even a non-party come under the contempt if he had a knowledge of the order.
We had the knowledge of that.
So Seawald principles you go.
That observation.
Why should you go do it?
With that observation, your document.
No.
I find the contempt.
No observation. You have to find out the law. You have to find out.
Liberty and why
we will not give you anything.
For my liberty has been granted to move a place.
Yeah, that's true. That's why I'm saying.
Therefore, if I go for contempt, my lord, that may be put me in trouble.
I do not know.
File it, then only you can know the test.
That you will put in the file. That's observation, only objection.
Oh, oh,
Receive that of observation, nothing else.
I have to do it.
Devotee, I'm not my lord asking for my lord, your worship may. Only an
Nothing.
observation that if it is you violated, then.
No, no, why should I? Or why should we rather? Once it is intertwined with the other, then
May take appropriate remedy, my lord. I take appropriate remedy, only I.
in a civil side, if you have filed a plaint and a relief is claimed, subsequent event has come which requires a molding of the relief, which also requires an addition of party, will you not take out an application under Order 6, Rule 17, read with Order 1, Rule 10(2) of the court together? So why not?
Mr. Mahanti is clever.
No, he made me to understand. That's why I gave you example.
I know that.
So that's why.
I know that.
Then why you say he's not a party to the proceedings? Why you say so?
Because my lord is not necessary party to that question.
Why not? If somebody, and then what is the definition of a legal representatives under section 2 of this Code of Civil Procedure? Even if somebody intermeddles with the state or opposition, he is
1964 Supreme Malpariat case, my lord. What I have remarked, it was 705 page. Necessary party and proper party.
That is the Rajia Begum's case.
That's the previous case.
So Rajia Begum's case is the best case.
Then three judges bench case is that Malpariat case, my lord.
So that is the best case, Rajia Begum. It is being consistently followed. Question of status is a very important factor. It will not only affect the present generation, but the generations to come.
That forms up for legal error, my lord.
So
Necessary party.
why don't do?
Will be a party to a proceeding that has been in Malparia's case, my lord, that has been decided.
So what to do?
Lordship can only grant. Lordship observe that.
No. Why observation? If you have a legal right, you can assert your legal right. Why observation? Law is to be pleaded under the Code of Civil Procedure. No, law need not be pleaded.
Law is not required to.
So why the law? Why the law is to be shown there? Your remedy. You have a remedy. You take remedy under the law.
That observation. That only. That observation is not. That observation may be.
The impugned order does not foreclose the door of
T9 already received the instruction. And again, from the single judge order regard to the seniority is concerned. And the NR is the repetition number 83 of 2026. The appeal number 2 file a SL with the Supreme Court and it was dismissed. So in this conjecture, I will. Response number 2, sorry. So 5% were dismissed. Again, it was remanded to the High Court, so there will be confusion as well as some time.
Remanded to the High Court, dismissed, then why remanded?
So there is a
No,
the groups have gone to apex court.
No.
And it was returned back.
He's saying no, Mr.
No,
He's
we
saying
have
no.
not.
We have response number 2 has gone, this is the order. But I don't have all these verifications. So if there, must give some time and come a details note, then
Last occasion, accordingly, I have given him this. Already compilation I have given all the details that their compilation was there. Last occasion I have given to my lunch senior.
I've already. What I'm saying, I will leave some one time after that I will come to the court will check. Some documents is there, is recorded because one order is passed, then it's released. Again another group has come, telling the said order, again another order was passed. By this process they are going one after another. Everything is taken care of by the honorable single judge, passed an order. Everybody disclosed that this is the case has been disposed of. Accordingly, an order was passed and it's been prepared. Again, they are telling. And now they are saying that something is suppressed. Check it up, my lord. 15 days time. After that, we will finally get hard and display.
it's the last chance.
Yes, that's what we last. Earlier, I took time. Earlier, episode I took time. Again, there is a confusion to me. So, I take time.
No, the confusion will never be over. More, the new authorities will come, more the confusion will be.
Ramu is the death chat problem.
Yes,
I have
death chat.
everything.
They are given, we will give.
Look at the presumption. Only based on
This is still the finalization of the seniority list has not been done.
Yes, already been done.
already been done. Published. Last occasion, I was directly instructed my lunch senior not to take any action. Every time my lunch senior is taking time.
Before that also it was.
Not to take action.
After the honorable single judge, we have finally list.
It has been done.
Taking into consideration all these documents.
The DSGI asked for an accommodation. Yes.
Regularization of service.
No, 40 delay is there. Delay is there.
Considered.
We have condoned.
Last exception, the matter is stated, you should be dismissed.
No, not at all.
Observation.
That we had a different mindset. Now we are different. We want to allow.
Because the lawsuit stated last occasion that resolution is there and how you are paying them. And they have said that through all
It
this,
is
thing,
condoned,
your
it
lordship
is
has taken
condoned.
a point that it will be dismissed.
It is condoned on 23rd. March.
There's a lordship was following the lordship.
For dismissal of the main application, this condemnation was allowed.
Because I want it should be heard and thanks my that your lordship has already passed the order for regulation favors and that every compilation is there now, my lord, except fraud and forgery.
Yes, you are challenging an order of 2nd of February.
Yes.
Huh?
Yes.
No, 4825 or
4825. Answer 1.
Where is, which page?
Page is 16. Page 16. Here is a clear case of error of record. Say.
Yes. Yes.
In the present case, the petitioner, the respondent, the writ petition, he was initially appointed in the year 2011.
Daily wage.
No, unskilled labor to work in the residence of the chairman of Odisha Administrative Tribunal. He was worked for 3 years there as unskilled labor doing outside job, gardening or other functions. While he was continuing there in 2013, the contractual rule for Group C, Group D post that was enacted. So that rule came in. under that rule, it is decided that any appointments made by the government shall be on contractual basis, and after initial appointment is made, 6 years after their service will be regularized. So after this 2000 rule came into force in 2014, 4 posts of peon was sanctioned by the government for appointment in the Odisha Administrative Tribunal. And the procedure has been prescribed how they will be appointed. Without following any procedure, these unskilled laborers have been adjusted by the chairman in that peon post. They continue silently without any intimation to the government. In the meantime, they continue. After 4 or 5 years, the tribunal has been abolished. After the Odisha Administrative Tribunal has been abolished. After abolition of the tribunal, they submitted a representation to regularize our service because we have completed 6 years of service as a contractual employee, so we should be regularized. So on the basis of the illegal appointment made in the year 2014, they recommended the state government, the tribunal recommended to the state government for regularization of their service. That was negative. Because the appointment was absolutely illegal, no procedure has been followed, no vacant post was there at the initial stage. So, and their appointment was not as against the post of peon, and they were appointed as an unskilled labor.
But your counterpart who appeared, I think your counterpart in the single bench.
Yes,
has
that is
said
the error of
something
record. I
different.
say you will kindly turn to the impugn order itself, paragraph 6 at page 20.
I think your counterpart there has said something different.
My counter.
No, in para 6.
Para 6 of this order, impugn order, the findings of the court, that having heard the counter parties and considering the submissions made, then this court finds that the petitioner was initially engaged as a peon on daily wage basis. This fact is not correct.
Basing on a selection process.
Yes, that was a
As
selection.
found from Annexation 4.
No.
Annexation 4.
Annexure 4 is subsequently those are regularized, they were adjusted against the post of peon. They have taken note of.
They were engaged earlier, adjusted in that created.
So earlier in 2011, they were appointed as peon, as unskilled labor. In 2011.
You read thereafter. In the state selection
Yes,
process,
I am reading it.
11 candidates.
Yes, I am
The
reading
selection
it.
committee recommended 6 candidates.
Yes.
Which includes the present petitioner being placed at serial number
Yes,
2.
that was appointed as unskilled labor.
Exactly.
So subsequently in 2014, then paragraph 6.1, basing on such selection process, so initiated, petitioner was initially engaged on daily wage basis as a peon in the year 2011. So that engaged as a peon, that is error of record.
Yeah.
It's not peons. Subsequently, when 4 posts of peon on contractual basis was created by GA department by letter dated 25/10/2014 under answer A/1, the authorities adjusted the petitioner as against one such post of peon with issuance of order of appointment, that is 28/11/2014. That adjustment we say that illegal.
Tell me, out of 21,
Yes.
6 were selected as a daily wages, daily rated worker,
Yes.
correct?
Yes.
How the 6 have been adjusted?
They have been adjusted against the 4 posts, and all others they left the job. They are now they have left the job.
They left the job,
Left the job.
all 5.
All
No, all
now only 2 persons are on, others have left.
no, out of there are 4
Out of
posts.
6.
4 posts were created.
4 posts were
6
there.
persons were selected. So
Yes.
2 persons left, 4 persons continue.
Yes.
What you have done with the other 4, other 3?
Other 3 are continuing.
They
or
have
what?
left the job. That no more continuing.
There is
The present petition is now continuing, and another.
No, they have been sent to other government department, no, after the abolition.
No.
Yes.
They were.
Yes.
They have to.
Where is your client posted now?
They left.
I'm at the office of the OAT, my lord. OAT is functioning officially. What the records and all this bringing
So
records.
there is no chairman or vice chairman, nobody is there because they are
No,
under compulsion.
He has been abolished, but the office.
Office, they are
Reports
in
and
the
other
office
things.
now. Now they are working in the office actually. Because there is no other place to work.
All is 280.
That is the decision for
That because of my contempt, they have
the number of cases
that there were
they have.
contempt matters, and government never cared the contempt matters in the OIT. So there is a
But these
personal
orders
appearance
were
of
not
one.
complied.
Yes, exactly. One or two very strong IS officers' personal appearance, they have on our persuasion a tribunal passed. So they decided to abolish the.
So on you
This on executive power they have passed the.
Defying Article 323, capital A.
rate of disclosure was very poor there.
More than 90%, 100%, only 20% cases come before the High Court. We are practiced there only. We know, my lord. That was so well, only because of they have sold some teeth and they have abolished.
No, not at all.
It is not in your government, it is the previous government. Why were we
There is no bother about the government. Fact is,
Infrastructure is ready.
My lord?
Infrastructure is ready.
Sir, my lord. The two buildings in Bhubaneswar and very effective members are there.
Mr. Swami, in an appropriate case, we will definitely think about it.
for all cases were.
High Court unnecessarily
Reason High Court is over, because that abolished both the tribunals. That's why High Court is
Both the tribunals, both.
two benches were there.
Oh,
that is circuit bench.
Four benches were there.
No, that is circuit bench.
Parampur and Sambalpur.
Man
also. But my lord, release of LP, last payment, last pay order, we have to come the High Court. And all type of harassment is going on for small thing, for salary, for that send us the LPC, we have to come before the High Court. This is the fact, my lord, and there lot of, and every recruitment, we have to come before the High Court.
Before the tribunal, so also in the before this court also. In all cases, because High Court is nearer to the tribunal, in all cases, they by filing the application, they are serving the order of the tribunal. So both procedures, both this honorable court as well as tribunal are loaded with cases service matters.
No.
Yes, in almost all cases, writ applications were filed. Even interim order, final order. So
Only the government has writ appeal.
It is the government who was
before
filing.
it was all right. After first case, it was loaded with.
No, L. Chandra Kumar, I am conscious, but what I am saying, government is filing most of the petitions.
2024 rate appeal number is 2,985. That is mine. So 3,000 rate appeals filed by any single bench order, my lord, rate appeal filed. And it is government. Government is the most biggest litigant now. Not any order.
With a delay for 2 years also.
Not complying any order. And in contempt, they are taking a stand, writ appeal is pending. So everything. So this is the way how these cases are piling up.
Yes. That's all, Mr. Swami.
No, in the present case, it is absolute.
Just say that 2011, he may be there in the employment, but not against the sanctioned post. 2014, 4 Pune was created. He was adjusted against one.
Without knowledge of the
and without the knowledge of the government, yet the government continued to pay the salary, whatever did it. But later on, when you abolished it, they wanted that where we will go, then you said your appointment is bad.
No, after abolition of the tribunal, 6 years completed, and there is after completion of 6 years, in view of the rules, I am entitled for regulation. That we refused. For the first time we came to know about this abolition.
Correct.
That's why we have refused.
Refused. So refusal is the subject.
Refusal is the subject matter of the
Correct.
application. Now the return.
How much salary you are expecting?
I am getting my lord 10,000 now.
10,000.
Initially 6,000, then it has been like 10,000 now.
Yes, 10,000 rupees.
You must be getting regularly, you must be getting now. You continue as contractual.
And this matter is listed at the every interval of a week or 2 weeks. That's appearance is counted.
What is his age now?
I was 30.
36. No, 36 and 23.
He was
30.
appointed at the age of 24 years, 5 months.
39 years on.
Now 39.
39.
2011, he was 24 years.
Where is he engaged right now?
Right in office, OIT office, my lord, under the
No, you have any paper? After the abolition,
No, office is continuing.
all right, where is that? How you say that he is still continuing?
I will start
Which document?
Who pays the remuneration?
the government.
Paying still today.
Still today, my lord. Nodal officer, one OS officer appointed as nodal officer.
That is there.
Because they have to, I always meet him because he has to bring the documents and cases, files to before this High Court. That's still in Bhubaneswar, then coming to Cuttack and doing all such work.
Old records are there whenever necessary.
They're taking steps for that old records. That infrastructure
Is
is there.
there other workers are also there?
Other
One or two, three workers are there.
4 dealing assistant, 1 nodal officer.
On the next.
From 41.
Yes, sir.
What is your right? What is your right on the land? What is your right on the land?
Right, I have been possessing over since more than 30 years.
30 years.
And that too, I have already.
On a government land.
Not government land.
Not government. Show us the record of right that it is not recorded in the government.
It is the, sir, just I explain to that effect.
Not explanation.
Yes, sir.
Show us the document. Very specific question. You say you are not occupying a government land. Show us the document. ROR that this land is recorded in name of another person, not government.
Now suppose any person who possesses the land, over the land, if he has not created any document.
So if
he has not created and he obtained any document from the area, what he possesses the land over the physical possession, de facto possession.
Adverse possession against the government land.
No, sir, that is a different issue.
That is a different issue. That's the main issue.
Put question whether there is a document, some document.
No, you say you are possessing since last 30 years. I say in respect of a government land.
Not a government land.
Then you say not a government land.
It is illegally.
Then if it is not a government land, must have been recorded in the name of somebody else. Have you produced the ROR? ROR will show.
In next data I will produce documents to that effect.
Why you did not produce it in the single bench?
Your Lordship, what happened? Please kindly the incognito. Given affordable opportunity, passed order.
You argued.
No, sir.
You are a writ petitioner.
That question.
Did you not argue the matter? I am asking you.
No, sir. No, yes, sir. But question did not arise at all before him because at the threshold without any giving any opportunity.
You were given an opportunity, sir. Whom he will give? The learned judge will give the opportunity to whom? To you.
Yes.
He has given an opportunity to you. Did you not argue before him?
He did not wish for to produce the document.
What?
He did not produce. Wish for produce any document.
Why? You have annexed all the documents with the writ petition?
No, document I have filed it. But court as of now, in the meantime, court wants to produce the documents.
Why the court wants?
Sir, let me finish.
No, I am unable to find out what you are arguing.
If any document court wants, then by next date I will supply.
No.
Yes.
Sir, this is not, sir, rule of pleading. The rule of pleading does not permit that you will hide a document in your pocket or a back pocket and will produce the moment the court asks you.
Challenge the improvement order, sir.
Correct. You have challenged the improvement order on the score. I am asking you on the score that you being a settlee or say you are there in a settled position since last 30 years cannot be evicted under the Act. Correct?
Settled principle.
You cannot be evicted under the Act. That's not a settled principle of law. It is not a settled. Anyhow. That is what your case is. Then first question arises, mere long possession creates any right in you?
Yes, by virtue of adverse position.
What is so according to you, even a long possession automatically becomes an adverse position. Is it?
No, that must be three ingredients satisfied. Neck come, neck precarious.
So when it says neck V, then neck V, then you understand the word V, then said neck clamp, you should know what is a clamp, and then say neck precario, then you should know the precario means. So mere long possession does not become an adverse position.
I know.
Continuity, hostility, reverberation, where, how? Then second question, can an adverse position be claimed against the government land? Second question. Let us see adverse position. Can it be claimed against the government land? Yes.
If any communal land is different footing. Every land can be made. Irrespective of certain lands.
No.
That is Supreme Court and categorical statement.
Show us. Don't take for the adjournment. I have the judgment against you. I can give you.
Let finish my if opportunity not given, how
I am asking you, don't say something in the pretext of an adjournment.
Not pretext, but not
sure.
that document.
You should come ready. You should come ready. This was issued.
No.
No, not. It's not in his case.
Yes, it's in this case.
In this case, eviction notice was issued against him? No.
What?
No, I'll say.
Already
No. Was it issued or not? I believe you issued. That's why he came before the court.
Sir, already issued.
In notice of 16 December 2025.
That's for your opposite parties.
No, I am not. Yes.
Your Lordship, letter, read petition. Annexure copy of the eviction notice. Yes, Lordship. Annexure 2 series. From page 13 to 15. That notice. Notice is not issued to the appellant, but clandestinely they fixed the same very well near about the Supreme, not acknowledging to the appellant.
Yes, continue.
You're not acknowledging the petitioner, the notice was, although notice was issued by the respondents, by the respondent opposite party in the writ petition, without any without any notice acknowledging the appellant petitioner. But that notice was affixed very adjacent to the land in the conspicuous place. That the notice was affixed by them. Without but no individual notice or any notice was issued by them to the appellant petitioner at the time of eviction. And at the same time, clandestinely within 2 or 3 days, they have evicted forcibly.
You are gone.
They evicted.
You are gone already.
No, not gone, but yeah, they have a party. Partly evicted.
One room.
Then we as of now, we possess the land over the supply.
But under the sun or what?
Yes, sir. What happened? That happened for a moment. I don't know. Get in front of the land was broken and damaged by them, and some fixtures which have been made by the appellant that has been removed forcibly.
Only the notice has gone. They have to file the reply. You have to consider.
PMC.
Notice for eviction
By PMC.
is only issued. Notice the order of eviction has not been passed.
It's not in the writ petition, also documents are not attached to him, also in the writ appeal.
You go give a reply to a notice, they will consider you. Take that neck V, neck clam, neck precario. Take that plea there.
Lordship, no. Lordship put question, what is the meaning of, what is the definition of the, so that I reply. The 3 ingredients are to be
So
satisfied.
3 ingredients are there. Continuous, hostile, uninterrupted, and to the knowledge of everybody. And hostility is a very important factor. When you have made a reverberation that I have become owner by virtue of a position.
Animus decidendi.
Animus decidendi is a different concept.
Different concept, but animus is very meaning.
So when you have created, when you have said, my position has become hostile.
That what happened at the same time, at the particular date, 29th of last year, December, they have forcibly evicted.
Forcibly evicted you? Then nothing is there.
Without
he is already evicted.
Without issuing notice. And single bench, single bench has passed order, paragraph 3 of its order. Admittedly, the petitioner is a forcibly encroacher in respect of the government land mentioned in the notice.
Once you are challenging a notice, that means you are you are occupying that land.
Occupying land since more than since it is the government, not it is the government land. It's the Lord Lingaraj, belongs to Lord Lingaraj Mahaprabhu.
Huh?
Yes, it is not government land, not belongs to government land.
You have also imposed upon the Lord Lingaraj Mahaprabhu asset.
Wrongfully, the revenue authority